Now, more from the symposium on the 30th anniversary of the release of the Pentagon Papers. In this panel discussion, participants talk about the confrontation between the press and the government caused by the paper's publication. Speakers include the former general counsels for the New York Times and Washington Post, and director of the Voice of America, Sanford Unger. This portion of the event is just under 2 hours.
I don't know if they are. Yeah, this is for the recording, I think. Okay, this first morning panel, the confrontation between the press and the government, will be moderated by Vietnam Veterans of America's General Counsel, Michael Gaffney, who is also a Vietnam veteran. Michael.
Oh, thank you.
Thank you. As you know from Dan Ellsberg's comments and from your own reading on this, the Pentagon Papers was an extraordinary legal event that represented a confrontation between the press and the government. That confrontation started in New York when the Times decided that they were going to publish. Our panelists will discuss that confrontation as it unfolded in New York and in Washington, and as it has come to be viewed in the light of history and subsequent information that's become available. I'll introduce each of our panelists, and the notion is that there'll be approximately 15 minutes per panelist to speak, and then that would leave about half an hour for questions and answers. To my immediate left is James Goodale. Jim was the general counsel in New York Times in 1971 when they were presented with the question of whether or not they should publish this collection of classified documents that had come into their possession. We know what the answer to that decision was, but he will tell us how that decision was made, what was involved in it, and his own judgment about the extent to which the papers contain information that could or would have been damaging to national security if they had been revealed. To his left is Hedrick Smith, who reported on Vietnam, from Vietnam for the New York Times. He replaced David Halberstam there after David Halberstam left and returned to the country, did more reporting from Washington on Vietnam, and was in New York, was part of the team in the New York Times that worked on the Pentagon Papers. Neil Sheehan also was part of that effort. We had sought to see if Neil Sheehan could be available for this, and he's apparently working on a book and couldn't be here. But the other half of the team, Hedrick, is here. To his left is Don Oberdorfer, representing the Washington Post team. Don had reported on Vietnam, from Vietnam, and in 1971 published the well-received book Tet, about the Tet Offensive. Don will talk to us about the Post decision to publish, because sequentially the way this worked was that on June 13th, 1971 in New York, if you picked up a New York Times, and at that point I was a college student on the GI Bill, had been back about 2 years, and I went down to the drugstore one morning on a Sunday and picked up the New York Times, and there it was. There it was. Don will talk about how it went with the Post, and he was one of a team of 3 Post reporters who worked on it. Chalmers Roberts was the other Post reporter, and Murray Martyr, who was invited and should be here. Murray. I called Chalmers Roberts to see if he would like to join us, and he said, I wish you the best. I'm 90 years old now, and I've got a doctor's appointment on Tuesday, and I don't think I'll be able to be there, but I hope it goes well. And then moving down the row, again from the Washington Post team, Sanford Unger, who's currently the director of Voice of America. Sandy, at the time, covered the story for the Post, and then in 1972, a year after the Supreme Court decision, published a book, The Papers and the Papers, about the legal struggle that had gone on with the Pentagon Papers. That, in 1973, won the George Polk Award. Sandy then went on to become dean of the School of Communications at American University, and in the Clinton administration has become director of the Voice of America. He will be leaving there in July and will become president of Goucher College in Baltimore, I believe it is. And then finally, not finally, but next to final, Bill Glendon is the lawyer who, in 1971, represented the Washington Post in the district court here in the District of Columbia, in the United States Court of Appeals for the District of Columbia, and in the United States Supreme Court when the case was argued on June 26, 1971. The pace with which this case moved through the federal courts was phenomenal. I mean, you got a little bit spoiled when you saw the election case move through because that went fast. But this was fast track. June 13th, initial publication in New York. June 15th, temporary restraining order in New York. June 18th, the Washington Post publishes down here. Government rushes in, tries to get an injunction. There's some scrambling around in the appellate courts. June 25th, the Supreme Court decides, we will take this case, both the New York case and the Washington case, and we want to hear you argue it tomorrow. 3 lawyers argued that case in the Supreme Court. Bill Glendon is one of them. The other 2 lawyers are no longer with us. One was Alexander Bickel from Yale University, a First Amendment specialist. And then there was Ernest Griswold, who was the Solicitor General of the United States, frequently referred to as the 10th Justice, if you will. The Solicitor General argues cases for the United States in the Supreme Court. He was also the Dean of Harvard Law School at one point, and you can listen to the oral argument in this case on the internet. In the web page that we put up, there is a link that'll take you to it, and you can hear Dean Griswold as he steps up in the Supreme Court and starts laying out the government's case for why the Supreme Court should not allow the papers to publish, prior restraint. Finally, on the end, David Rudenstein, a constitutional law professor from New York, from Cardozo Law School, who in 1996 wrote a book called The Day the Presses Stopped, which is a legal history of the Pentagon Papers struggle. And David had access to some documents that other authors haven't had access to. And his book is comprehensive, well-respected, and takes the position that there were indeed documents in the papers that could or would have damaged national security. There was no damage to national security from the papers. We know that now. But that is an issue that pervades the discussion about the Pentagon Papers. With those thoughts, then, I'll let Jim Goodale, former general counsel of the New York Times, tell us about it.
Well, this happened. Is this working? I don't think this... Okay, it is. This happened so long ago that I feel like I'm 90 years old, too. I appreciate all the interest you show by coming and hearing about this, and I'll give you my selective self-laudatory reminiscence of what happened. I was given the... and by the way, I want to assure everybody, and this is a little more serious than the previous remarks, that I never thought that I was engaging in an act of civil disobedience, and I never had a doubt as to what the law was. And I must say I didn't have much doubt as to the way the case was going to come out, too. But I was one alone. I picked up the papers. No, I didn't pick up the papers. In fact, I was told by the Times that they had some classified documents with a wink and a nod. That's all they said. I knew that meant I had to go up and look the law up, and I did. I was staffed with 3 lawyers who were doing other things, and I had a summer associate from Columbia. And when we looked at the law, we found 3 things. One, an Espionage Act, a law that says that you stamp documents classified, top secret, so forth and so on. And lastly, a famous case called Neer versus Minnesota, which held, generally speaking, that you can't get injunctions against the press. I started parsing the first, the Espionage Act, and I was confused that when I read it, it couldn't seem to fit the facts of what we were doing. I didn't know at that point that when the act had been passed, it was passed to cover espionage, and the testimony on the floor of the Senate made it very clear that the First Amendment would not permit it to do anything else. But since I was staffed with one summer associate, all I had to do was look at the language, and the language told me, regardless of what legislative history was, you can't use it. The Stamping Act, where if you've been in the Army, you stamp documents classified, seemed to me totally irrelevant, applied to the people in the government, didn't apply to the New York Times. And with respect to getting injunctions in court, I had a lot of experience in that. I'd been at the time 7 or 8 years. I'd read all the cases, and there were some state. I knew there were no federal cases ever granting an injunction against the press in the history of the United States up to that point. So I knew what the three sources of the law were, and I then had to figure out where the risks were. And the risks were, number one, I thought, getting an injunction. And number two, there was some slight risk that there'd be a criminal prosecution, but I didn't think that was going to be a real risk, because when the Pentagon Papers were given to the jury, I didn't think the jury was going to convict. That was just sort of a judgment. It's a risk. I was really worried about the injunction. But at this point, I hadn't seen the papers. I did all the analysis without seeing the papers. So one day they were rolled into me, you know, card after card after card, 52,000 volumes, and they said, here you are, go read them. Well, I didn't know what to do, but I did start reading them, and I read the first few chapters. And as Daniel Ellsberg said this morning, they pointed out a history of deception which surprised me had begun so early in the history of what we're talking about. That is to say, right after the Second World War. And I found that history fascinating, because I didn't know about it. So I started to ask myself, can the government stop us from publishing this? Then I looked at the sources for the information I was reading. New York Times, New York Times, New York Times, see page, New York Times, see page. I said, oh, come on. The government's going to go into court and stop the publishing? New York Times publishing from something it's already published? It can't be. So I then had to take all the above, what lawyers do, they take the facts and the law, usually take it the other way around, but in my case it was a peculiar situation, and I had to make some judgments. Now, I didn't come at this as a naif. I'm an old-time liberal Democrat from age 12, an FDR fan from age 7, and a Nixon hater from the days that he ran against Jerry Voorhees and Helen Gahagan Douglas. And at one point in time, I could have told you the circulars that Richard Nixon had sent out, either in the Voorhees election or the Douglas election, that brought him the bad reputation that he had in liberal circles. I knew Richard Nixon like a book. I also had a lot of experience with classification, and I knew what the armed services thought and the government thought about classification, including I was familiar with the idea of overclassification. My judgment was that if we published this in installments, the government was going to come in and join us no matter what, because the government had to protect the sanctity of the classification system. They couldn't let a huge leak like this go by. My own theory was what would happen was that the Joint Chiefs would go to Laird, Laird would go to Nixon, and Nixon would let it rip. Now, David Rudenstein can tell you exactly what that history is. If he can't today, you can read in his book. I'm off a little bit, but I'm not off that much. I hadn't figured Henry Kissinger's role in this when he had played a prominent role. But I don't care what Henry Kissinger's role was. I knew what Richard Nixon had done. I knew what he'd done in the Alger Hiss case. By the way, I think Hiss is guilty, but I knew his frame of mind, knew what was going to happen. And I knew he was going to bring an injunction. I told the Times that was going to happen, and what they ought to consider is publishing it all at once. Because if they all publish it all at once, you can't get an injunction, can you? And from a criminal point of view, if you go into the grand jury, the government's got a sort of funny case. He's got to show this is what they published and look at it, and then they can't go to the other parts of the Pentagon Papers and say, look, how much this other material will hurt national security. They got to look at the newspaper itself. Well, a side point. Did I think the material that I read damaged national security? Well, confess, I did not read all of the Pentagon Papers. The only person in the world who probably has is David Rudenstein, or perhaps the editor of them. But the material that I read, and more relevantly, the material that was published by the New York Times, in my judgment, did not damage national security, and was in a sense a bunch of hokum. However, I will admit, from the government's point of view, the government certainly could have come to the point of view that it thought it damaged national security, and I think that's David Rudenstein's point of view, and that's why I concluded, indeed, that the government was going to take the action that it took. Well, it seems pretty simple, doesn't it? Well, at that time, I was 37 years old, and of course a young 37, because that was a long time ago. But when you were 37, 30 years ago, it wasn't the dot-com age. I mean, you were 27 by dot-com standards. And when I brought this point of view to the management of the New York Times, they did not take it kindly. and in fact did an end run around me and went directly to the law firm where I'd started, Lord Day & Lord, to the ex-Attorney General of the United States, Herbert Brownell Jr., and to a former president of the New York City Bar Association, which is a big deal in New York City, and asked them for their advice. Now, I don't know what they based their advice on. I honestly don't think they could have looked at the law, thought about the First Amendment, or done a lot of other things they should have done. They advised at times it was criminal to publish the Pentagon Papers, and that they, the lawyers, would find it a criminal offense to even read the Pentagon Papers. And what ensued thereafter was my superior and I had a series of arguments that went back and forth that really just drove me crazy. And I had to leave the Times right in the middle of this because my wife had we had a baby. My wife had a daughter. I had a daughter. I went to her in the hospital and I said, I'm sorry to tell you this because we have a new financial obligations, but I'm going to resign from the New York Times unless they publish the Pentagon Papers because there's no point in being there if I'm going to be run around. Well, I came back after a short respite with my wife, and I found that for reasons not entirely clear to me to this day, that all of a sudden the idea of publishing was going forward, even though outside counsel had advised that it was criminal. And I looked at the material to be published. I looked at the documents that went along with the prose. I was worried about publishing the basic documents that went along with the prose, but after I read them, I wasn't so worried because I really thought they were rather outrageous. And off the publication went to really not much of an interested audience on a Sunday before the week in which the litigation began. I came back on Monday, and guess what? Laird went on television and said, our national security system is at risk. And I said, oh, here we go again. Now, I was very lucky that day that Alex Bickle had come into my office because we were working on another case involving a New York Times reporter called Earl Caldwell. And we went off to lunch with Reuben Frank, who's the head of NBC, and on the way over, he said, that was a great thing that you did. And I said, great. He said, in fact, it's a lot easier case than the one you give me on Earl Caldwell. And we had lunch. I went back waiting for all hell to break loose, and it hadn't. And I went home, and it was about 7 o'clock, and I said, geez, you know, Laird went there. I know something's happening. So I called my superior, and I said, anything going on? He said, yeah, we've got a telegram here saying that we ought to stop publication. Well, do you think I better come over? Yes, you better come over. So I went over to the New York Times, and I walked into a room where Abe Rosenthal, Harding Bancroft, my superior, and Sidney Grusin were all yelling and screaming at each other as to what they do with respect to obeying or not obeying what was in the telegram. I inserted myself, and I said, well, you can't obey a telegram. I mean, there's a question whether we should even obey a temporary restraining order or an injunction. I mean, that's an open question. But in this case, it would be foolish not to obey it. But a telegram? And so we went back and forth, and somebody said, well, let's call Punch Sulzberger. Punch Sulzberger was was in London then. He had left just before the publication. And we woke him up and got him out of bed. And they screamed and yelled. And then finally Punch turned to me. He said, well, what do you think we should do? Will there be any more liability for us if we go ahead and publish? I said, I think there may be a tiny bit more liability, but I don't think you really have liability for publishing. He said, well, let's go. So off he went. And now the question was, since the government had threatened in that telegram to go into court the next day, what we're going to do with respect to legal representation. So after a long wrangle again, because it took time to make decisions on the top of the New York Times, we ended up talking to Herbert Brownell about 11 o'clock at night, and I said, Herb, you look great at the Nixon wedding. The Nixon wedding had been the Saturday before. I said, I expect to see you in court with some of your pals from Lord Day & Lord. He said, absolutely not. I said, absolutely not. I had a little perspiration on my brow at that point. He said, well, I drafted that classification document that you talked about, and if I go into court, I'll have to defend it, and I can't because I drew it. I said, well, okay, but I didn't really believe him. I don't think he wanted to have anything to do with the case, and as David Rudenstein will probably tell you, he'd received a call from John Mitchell earlier in the day, effectively telling him that it probably wouldn't be a very good idea for the Republican Party if he were in the case. So then what to do? Well, Bickle. He was our only hope. But we couldn't find him. And so it was then midnight, and I knew that we were probably going to be in court the next morning at 10 or 11, what to do. I said, oh, to hell with it. I know as much as they know about it, having been through the Attorney General of the United States, the City Bar Association president. They didn't know anything about it. I've been thinking about it and all these issues for 7 or 8 years, generally, this one particularly for 3 or 4 months. I'll argue it myself. The only one problem with that, I'm not a litigator, but that's why so I went out of there, went home, and about 2 in the morning, the newsroom had called from, the people in the newsroom called me and said, we found Bickle. I said, great. I got Alex on the phone. He said, I'll do it. And I said, well, if you get this Floyd Abrams and Cale Gordon to join you, I think we've got a team. And off we went, and the rest is, as they say, history. I suppose Bill Denton will pick up where I ended a little bit in terms of this legal chronology. Thank you.